Welcome back to the deep dive. Today, we are opening a file that sits right at the intersection of, well, human tragedy and some very cold, hard legal technicality.
It's a fascinating and difficult area of law.
We're looking at medical malpractice specifically through the lens of a really important 1974 case from the Maine Supreme Judicial Court, Downer v. Veilleux.
And it forces us to ask some very uncomfortable questions about what we expect from our doctors versus what the law actually demands of them.
Exactly. I mean, you have a severe car accident, a patient with a permanent disability, and a doctor who had to make a really tough call in a crisis.
Right.
So the central question we're tackling is this. When a physician makes a judgment call and it leads to a poor result, is that automatically negligence?
And, crucially, what role does an expert witness play in proving it?
That's the one. So where do we start?
Well, to really get to the bottom of this, we need to structure our deep dive. We'll look at three core legal doctrines this case really brings to light. First, the general standard of care and why expert testimony is almost always necessary. Second, this very specific idea of a duty to consult a specialist.
And the third?
The doctrine informed consent. We'll get into how the court thinks about it, separating a battery theory from a negligence theory.
And the mission here is to really dissect how the burden of proof works in these incredibly complex medical situations.
It is. We're going to see how the law deals with a scenario where, the treatment options are already severely limited by how critical the patient's condition is.
All right, let's unpack it. Before we even get to the specifics of Downer v. Veilleux, we have to set the stage. What is the foundational legal responsibility a doctor has to a patient?
For that, we can look to the general rule from cases like Coombs v. King. Essentially, a physician makes a kind of contract.
An implied contract.
Implied or expressed, yes. And in it, they promise to use three things. First, the ordinary skill of other doctors in similar situations. Second, reasonable care and diligence. And third, their best judgment in applying that skill.
That sounds reasonable. But I imagine there's a catch. Most people think if they pay a doctor, the doctor's supposed to fix them.
And that is the crucial caveat. A physician is not an insurer. They don't guarantee a good result. The law is very, very clear on this. An error in judgment does not automatically create liability if that ordinary skill and care were used.
That's a huge distinction.
It's massive. You're paying for the application of skill, not a guaranteed outcome.
Okay, let's test that. So say I go to a doctor, I get treated, but I just don't get better. In fact, things get worse. Can I sue for negligence just based on that poor result?
No, absolutely not. The courts, citing cases like Feeney v. Spalding, reject that out of hand. A poor result all by itself is insufficient. You, the plaintiff, have to prove the bad outcome was caused by a lack of skill or care.
So the outcome doesn't prove it. The jury has to look at the process.
Exactly.
But that creates a massive problem, doesn't it? I mean, how is a lay jury, people who didn't go to medical school, supposed to decide if a doctor used ordinary skill?
That is the hurdle. And it's why the rule for evidence in these cases is so strict. Because medicine is so technical, a plaintiff must bring in their own expert witness.
You can't win without one.
Not usually, no.
Yeah.
And that expert has to do three things. One, establish the specific standard of care. Two, show how the defendant doctor departed from it. And three, connect that departure to the injury. Causation.
Is there any way around that? Any exception?
There is one very narrow exception. It's called the common knowledge exception from a case called Sear v. Geeson. It only applies when the negligence is so glaringly obvious that any regular person could see it without help.
I need to visualize this. Can you give us a really visceral hypothetical to show the difference between that common knowledge exception and the complicated facts in Downer?
Of course. Let's call it hypothetical A, the glaring error. Imagine a surgeon is operating on someone and, oops, they leave a large metal sponge inside the patient's abdomen, or they amputate the wrong leg.
Okay, that's visceral and horrifying.
It is. But legally, it's simple. You do not need a medical degree to understand that leaving a sponge inside a person is negligent. That's common knowledge. It fits the Sear exception perfectly. A jury can just look at that and say, yep, that's wrong.
No expert needed to tell them that. Got it. Now, contrast that with the situation in Downer.
Right. Hypothetical B, the Downer reality. You have a patient with a completely shattered femur. The doctor has to choose. Do they use traction, weights and pulleys, or do they do surgery and pin the bone?
A tough call.
It's more than that. The choice itself affects the blood supply to the bone, the cartilage in the knee, the risk of infection. It involves biomechanics, vascular health. It's a complex judgment call.
I see. I can't just look at that choice and know if it was wrong.
Exactly. You can't feel your way to a conclusion. You need an expert guide to explain the risks and benefits. That's why the common knowledge exception doesn't apply, and the plaintiff must have an expert.
That sets the stage perfectly. So let's get into the case itself. Let's analyze Downer v. Veilleux. First, what are the legally dispositive facts?
Okay. The plaintiff, Mrs. Downer, was representing the estate of Christy LaJoie. Mrs. LaJoie was in a terrible car accident and was admitted to the hospital in shock with just a laundry list of injuries.
What kind of injuries?
A skull fracture, a shattered right knee, the distal femur specifically, and a broken hip, which is the femoral neck.
A real mess.
A real mess.
Yeah.
So Dr. Veilleux, the defendant, had to prioritize. First, he stabilized her from the life-threatening shock. Then he focused on the open knee fracture because the risk of infection or permanent cartilage damage was immediate.
Okay, makes sense.
Now here's the crucial part. For the broken hip, Veilleux chose to use traction instead of surgery, a procedure called pinning. He did this because physically manipulating the hip for surgery would have risked destroying the fragile repair he'd just done on her knee.
And the result?
The knee healed well. The hip did not. It resulted in a non-union, meaning the bone didn't fuse back together. So the plaintiff sued him for failing to fix the hip, for not consulting an orthopedist, and for not telling her about the other option.
Then what was the core legal issue?
The issue for the appeal court was pretty narrow. Did the trial judge make a mistake by granting a directed verdict for the doctor? In other words, did the plaintiff actually present enough expert testimony to even let a jury decide the case?
What rule of law did the court apply? Can you state the full black-letter rule and then break it down into its testable elements for us?
Absolutely. The court applied the medical malpractice standard of proof. To survive that directed verdict, the plaintiff had to provide evidence on 4 key elements.
4 elements, what are they?
1. Standard of care. You need expert testimony to establish what an average, competent doctor would do. 2. Breach. Expert testimony showing this doctor's treatment departed from that standard.
Okay, standard and breach.
3. Causation. An expert has to link that departure directly to the injury. And 4. A subrule for informed consent. Proof that a material risk came to pass, and that if the patient had been told about it, they wouldn't have agreed to the treatment.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the alleged negligence in choosing traction over pinning?
Right. So the sub-issue was simple. Did the plaintiff's own expert, a Dr. England, actually testify that Dr. Veilleux's use of traction was a breach of the standard of care?
And did he?
No. This is where the plaintiff's case just collapses. Dr. England admitted on the stand that using traction was not necessarily bad, and given the other injuries, it might have been the only real option. He couldn't even say that pinning the hip was medically possible at that time.
So the plaintiff's own expert couldn't condemn the doctor's choice.
He couldn't. So the court's conclusion on that element was clear. If your own expert can't say the treatment was wrong, you haven't produced any evidence of a breach. End of story for that claim.
Understood. Now, what about the second element, this alleged duty to consult an orthopedic specialist?
Here the sub-issue was, does a general surgeon have a duty to call in a specialist just because a specialist might provide, quote, better handling?
That seems like a high bar.
And the court thought so too. In its analysis, it noted that while Dr. England called it bad practice not to consult, he also admitted he found no fault with Dr. Veilleux's actual medical work. The evidence showed Veilleux was competent in treating these kinds of fractures.
So it's about competence, not the job title.
Precisely. The court's conclusion on this element was fascinating. It said liability depends on competence, not specialization. A doctor doesn't have to call a specialist if they themselves have the skill. Forcing them to would, in the court's words, inhibit the practice of medicine.
Now for that complex third element, how did the court analyze the informed consent claim?
Okay, so the sub-rule the court uses is important. It moves away from thinking about this as a battery, like an unwanted touching, and toward a negligence framework. The duty is to disclose feasible alternatives and their risks.
The key word there being feasible.
The key word. In its application, the court looked at the plaintiff's argument, which was that Dr. Veilleux didn't tell her he hadn't surgically set the hip. But all the expert testimony, including her own, showed that pinning the hip was not a feasible alternative because of the catastrophic knee injury.
So you can't fail to inform someone of an option that doesn't actually exist.
You've got it. The court's conclusion on this element was that a doctor has no duty to discuss abstract treatments that are medically impossible for that patient. You can't be negligent for failing to offer an impossible choice.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Judicial Court of Maine affirmed the directed verdict for the doctor. The plaintiff simply failed to get over the expert testimony hurdle. There was no expert evidence of a breach of care, and no evidence that a failure to disclose caused any harm, since no other treatment was actually possible.
This analysis really shows just how difficult these cases are. It almost sounds like the plaintiff lost because their expert was too honest. I want to make this actionable. Can you convert this whole case into a diagnostic tool for our listeners?
Absolutely. Here is the step-by-step diagnostic checklist for spotting these medical malpractice issues.
Let's hear it.
Step 1. Check for obvious negligence. Is the mistake so gross like a sponge left in the body that it falls under the common knowledge exception? If yes, you might not need an expert. If no, you go to step 2.
Step 2 must be the expert.
It is the expert testimony barrier. Does the plaintiff have a medical expert? If the answer is no, it's almost certainly a directed verdict for the defense. If yes, proceed to step 3.
Okay.
Step 3, the standard test. Did the expert clearly define the standard of care for this specific situation? It's not enough for them to say what they would do, they have to say what the profession requires.
A critical difference.
Huge. Step 4, the departure test. Did the expert then testify that the doctor's specific conduct violated that standard? You have to watch out for experts who just say, well, I would have done it differently. That's not enough.
And the final step.
Step 5, the feasibility check for informed consent. If the claim is about a lack of informed consent, you have to ask, were the undisclosed alternatives actually medically feasible? If the patient's condition ruled them out, there was no duty to discuss them.
That checklist clarifies things immensely. It turns a tragic story into a very logical, if tough, legal framework. It seems the whole point of this deep dive is that a bad outcome, even a terrible one, is not enough.
It isn't. And if you connect it back to the bigger picture, the court was worried that if they forced competent doctors to always call specialists, it would turn doctors into insurers of our health.
Meaning they'd be on the hook for any bad outcome, regardless of fault.
Correct. Which brings us to a final provocative thought for you to consider. Does this really high burden of proof protect doctors too much? Or is it the only thing that keeps our medical system from grinding to a halt? If we lowered that bar, would doctors just stop taking on the riskiest cases, the Christy LaJoys of the world, for fear of being sued when the poor result inevitably happens?
That's the deep dive. Thanks for listening.